All right. Good afternoon or good night, everybody. We're holding this virtual meeting of the Lynn Zoning Board of Appeals today, August 25th. We're officially starting business. If we can have a roll call for the purposes of the record, please.
Recording in progress.
Yes, member Gilrain.
Present.
Member Massey.
Say Marcy?
Macy.
Marcy.
Yeah, Marcy. I said Marcy. Yes.
It's Marcy.
Yes. Here.
Here.
Okay. Member Catalise. She'll be here soon. Member Christopher.
Yeah.
Member Maggio.
Present.
Member Olson.
Present.
Member Crowitz.
Present.
Member Lopez Hernandez.
Present. All right, we're all here. We have a quorum. The only item in our agenda today is to have a presentation made by the planning department alongside BBHS. So we are passing it to Aaron and Lauren to take us off in the presentation. Thanks.
Thank you, Mr. Chair. For the record, I'm Aaron Clausen, the principal planner for the city of Lynn, and Lauren Drago's also here to support and done a lot of work related to the zoning amendment and much of the work that went into that in advance, including the comprehensive plan. Before I hand it over to Jonathan Silverstein from BBH&S, I thought I'd provide just a little background on how we got here and why we're here. I think many of you know exactly what's happening, but we started several years back working with this current administration and the community and other stakeholders to complete a comprehensive master plan called Vision Lynn. And that was our effort, the community's effort, to lay out a vision for the future of the city. Comprehensive plans, as many as you know, are really future facing, looking out 20, 25 years, sometimes more, to sort of establish what is our end goal, what are the objectives, what are the goals the city and the community want to achieve over that time, and then lay out a strategy to achieve those goals that can range from regulatory changes, capital investments, programmatic investments, so that it's all woven together to achieve that goal, because it does take everyone sort of pulling in the same direction. So it was an opportunity to establish that vision and tie together some of the previous work that's happened in the city, like the housing production plan called Housing Lynn, and then other sort of more geographic or geography focused plans, particularly the waterfront area with the waterfront open space master plan, municipal harbor plan, and some others. So Vision Lynn was adopted over 2 years ago now. And one of the key objectives in that planning process was to tackle and revise our zoning ordinance. It has been forever and a day. I think we've probably figured out when the last time it was comprehensively established, but it's been many years where sort of small changes have been made over time. And so coming out of Vision Lynn, which was really built around this idea of land use and urban form. How does development shape the city, and how does development in particular meet those objectives that the city and the community had articulated in Vision Lynn? And zoning, as many as you know, being on the Zoning Board of Appeals, is the strongest tool a community has to shape development and making sure that development is orderly, sort of orderly, created and implemented, but also meets the broader community goals. And so we embarked on this effort with Community Scale as the lead consultant in developing a zoning amendment, partnering here with BBH&S, and then really led by an internal stakeholder group to help sort of shape and inform that change. Many of the members on the call now, Jim Lamont is on the call, members of the Zoning Board of Appeals participated in that advisory group, as among other departments and agencies in the city. And as you all likely know, in June, the City Council adopted the zoning ordinance. So we have a new zoning code. There are elements of it that are similar or the same, but for the most part, it was a comprehensive reworking to make sure that the regulations, the development regulations, are aligned with the development goals articulated in Vision Lynn. So I think what that really means is that, I think all of you have seen a lot of applications over the years seeking variances and in some cases special permits, but for the most part in Lynn, you'll be seeing variances, and that's still the case. But given all the sort of engagement and work going into Vision Lynn, and then subsequently the zoning change that was recently adopted, sort of our expectation generally is that variances should be a much more seldom occurrence, because so much effort went into right sizing our guidelines, right sizing the density requirements, and lining up the development regulations with those goals. So that that would be a significant change coming out of this effort. And then also just to note that the plan itself, Vision Lynn, and some of the development objectives written into the guidelines will help, I think, some of the boards and commissions, the zoning board in this case, the city council as a special permit granting authority, help make decisions, again, whether it's a variance or a special permit. So this is a really exciting opportunity, I think, for this board, as well as some of the others, to sort of bring this into the implementation phase of this. We've done all this planning work, updated our regulations, and now this is an opportunity to move it towards implementation. So I'm going to pass it over to Jonathan now and give him a chance to sort of run through the legal framework and talk through how the zoning code, but generally more generally, I think how these regulations can be interpreted from a legal standpoint. So I'll leave it there. And I just want to ask Lauren, anything else that I should be hitting before I pass it over to Jonathan?
I'll just reiterate for folks that jumped on after we talked about it. We are recording this right now with the intention that it can be a resource for the ZBA for any future meetings or folks that aren't present. The intention is not to post it publicly at this time, but just wanted to explain that for anyone who missed it.
Great. Thank you, Lauren. And without further ado, happy to pass it over to Jonathan to kick it off.
Great. Thanks, Aaron. Excuse me. So my name is Jonathan Silverstein. I'm a partner at BBHS Law, and I was fortunate enough to work as a subconsultant to Community Scale on this recodification effort. And I want to, before I jump into my presentation, just sort of reinforce something that Aaron mentioned. I've been working on a lot of these zoning recodifications, and I find that one of the things that happens over time as the framework and underlying, especially dimensional regulations of a zoning code in a particular municipality starts to get out of date is it falls further and further behind both the reality on the ground and the actual planning objectives of the community. And so you'll see a situation where the community doesn't actually want to see the type of development that's allowed by right built. And you end up in a situation where there's a lot of what is often called zoning by variance. Instead of having the zoning objectives that you want codified, the only way to get development that the community wants and that makes sense is to do it by zoning variance. And so one of the objectives of a zoning recodification is to bring that balance back and make the zoning reflect better both what's on the ground and what the city wants to see. And so I think the objective here, and hopefully it's been achieved, is that there will be less need for zoning by variance, less need for the Zoning Board of Appeals to issue variances, and that tool, and I'll get to it in a little while, can become more of what it was intended to be, which is the exception rather than the rule. So with that being said, what I'm going to cover generally on this presentation are 4 general categories. One is types of applications that the ZBA should see coming in front of it under the new zoning. Within that is a significant subcategory, I think, that is going to change a little bit from probably what you're used to, which is dealing with zoning nonconformities. And then more generally, just some best practices regarding process, public hearings, and drafting decisions. I want to say that I always find that these presentations provide a nice roadmap for sort of trying to cover the big picture topics, but I personally always find that these training sessions are more productive if people just jump in as they have questions and talk about the things that you're actually seeing and that are actually coming up, and ask and you shall receive. I see that, and I'm fine if people just sort of jump in. Feel free to use the raise hand function, but I'm also fine if you just jump in and interrupt me. But with that being said, I see that there is a hand raised.
Yes, that's great. I have a question before getting into the substantive matters. So nonconformities may be something that we might be looking or being encountering more than maybe before. Is this something that was already kind of like, I'm guessing it's an Aaron and Lauren question, that while the overhaul was happening, the city knew that the changes would likely increase the amount or change the number of non-conforming structures around the city? Do we have any insight on that, or is it just that we knew that's going to happen because of such a
Let me
wide
actually
range of
clarify that. I think you're actually going to see more conforming structures and properties in town. What I meant was you're going to the ordinance provisions with respect to zoning nonconformities has been tweaked a little bit, and I'll cover that a little bit as we go through the substance. Obviously, Aaron, Lauren, feel free to jump in, but hopefully you're going to actually see fewer non-conforming buildings and properties in the city.
Yeah, just to jump in real briefly, I think, Ibrahim, one of the things you might be asking is as a sort of in terms of the requests that come to the Zoning Board of Appeals, that there may be more, Section 6 findings with, a special permit to extend or expand an existing nonconformity, whether it's a structure or use. We think there may be that coming in a little bit more frequently. And it is a bit of a policy decision. It's also, I think, just a function of the framework of zoning generally in Mass. But Jonathan will get into this in depth in just a moment, but we, from a policy perspective, decided to remove the option for use variances across the city. For a number of reasons. We if you want to get into that, we can talk about it more. So the loss of the use variance option for property owners or developers will tend to push them to use an expansion of existing non-conforming use or structure. There's still an option for a variance for dimensional requirements, but so we could see that uptick because it just limits the options for relief a property owner might have. We also on the non-conforming structure or reestablishing non-conforming uses have opened up a little bit more leeway for properties to rebuild after a fire, for instance, or reestablish an existing non-conforming use that was essentially vacated. So there's a couple of detailed things in there that also will have the possibility of increasing those kinds of applications coming into the ZBA. So, but
Great.
those are sort of, there were policy decisions behind that. And we can maybe, when we get to those those moments, we can talk a little bit more about that.
Great.
Just one other question. On special permits, it seems like there's a lot of categories where a special permit would be needed. And if something was built under a special permit and it's been a period of time, but they want to come back and make changes, does that need to go back to city council to make edits, even if that's 10 years later? Or how are those handled as those age, and who's responsible for that? Because they may be in a certain zoning area and it was built under a special permit that may not be totally in compliance with the zoning, it's non-conforming, but through the special permit process, it was built. But then any changes, does that have to be a change to the special permit every time they do something? Or how are those, what's the dynamic with those?
So that's going to be a pretty fact-specific question, but if we assume that it's a use that requires a special permit was issued, then the zoning changes so that the use is no longer allowed even with a special permit. That use has now become a pre-existing non-conforming use. And to change it would require a special permit from the ZBA, and we'll get into this in a little while, upon a finding that it's not going to be substantially more detrimental to the neighborhood. If the zoning hasn't changed and the use is still allowed by special permit and the council is still the special permit granting authority, then it would require a modification of that special permit, and that application would be made to the council. In terms of how substantial or significant a change triggers a special permit requirement, that's really going to be a function of exactly how the special permit conditions are drafted, and what the specific requested relief was. So definitely, some variables in there. It's hard to give you a one-size-fits-all answer, but it's going to depend on what's happened since that special permit was first issued.
So the planning department would direct traffic on which way an applicant may need to go forward?
I suspect so, or I know that there's this process that is generally followed where an applicant may go to ISD first and get either a zoning determination or a denial letter, and that's going to provide the roadmap. But hopefully applicants are doing their due diligence before they file applications with the ZBA for relief, so that someone in the city is determined that it's the appropriate relief, so that you're not left to try to figure that out on your own. All right, so here are the types of applications that the ZBA is likely to see. Appeals under state law of administrative decisions. Most likely we're talking about decisions of the ISD, but could be other types of administrative decisions. Special permits with respect to nonconformities, and we'll talk some more about that later. And that's really going to fall into two broad categories: 1, 2, and 3 family structures and uses, and then everything else. And then there are a few other areas where the ZBA is the special permit granting authority designated in the ordinance, such as I gave an example here for earth removal operations. Then variances, as Aaron mentioned, use variances are no longer allowed. And then I'm not going to cover this here. I'm happy to answer any questions about it. But of course, the ZBA is also the comprehensive permit granting authority under Chapter 40B.
So are we the only, so the city council isn't the only special permit granting authority. We also still have some instances where we'll grant special permits?
That's right. So you grant special permits in almost all areas involving nonconformities. And again, I'll get into that a little bit more detail in a while. And then there are a couple, and I think these are mainly unchanged from the prior version of the ordinance. There are a couple, I think, earth removal. There was something having to do with maybe parking reduction, I want to say. One or two other things where the ZBA was and remains the special permit granting authority. So just quickly on zoning appeals, the process is that someone has to file their appeal with the city clerk within 30 days of the decision that they're appealing. And then the officer being appealed or board is supposed to forward to the ZBA everything they've got forthwith. So whatever application materials and other correspondence documents that were before the border officer whose decision is being appealed is supposed to be sent to the ZBA. And then this is something that does come up a fair amount. Only a final decision is appealable, such as a building permit denial or a denial letter. If someone asks a building official, sends them an email and says, hey, do you think this is an allowed use? And they email back, no, I don't think it is. I think that would be a heavy industrial use and that's not allowed in the district. That's not appealable. So it doesn't come up a lot. It does come up from time to time where people try to appeal these sort of advisory decisions that weren't made based upon sufficient information and therefore shouldn't really tie the hands of, say, the building official to an off-the-cuff answer or opinion that they gave. And I always say to building officials, they should be really careful about providing advisory zoning determinations and making sure they have the information they need before they do it. Assuming a timely appeal is filed, then the ZBA has to open its hearing within 65 days, and it has to act within 100 days of when the appeal was filed. And then it has 14 days to file its decision with the city clerk. Now, what the courts have ruled is that of all these deadlines that the ZBA has, really the one that matters is 114 days. Within 114 days of the appeal being filed, the ZBA has to file its decision with the city clerk. And if it doesn't, that appeal is deemed to be constructively approved, meaning approved by default. Of course, all those deadlines can be extended by written agreement, but the written agreement has to be in writing, an email is fine, and it has to be submitted to the city clerk. So when the ZBA is acting on an appeal, it basically steps into the shoes of the border official whose decision is being appealed. It can reverse, affirm in whole or in part, modify the decision. Basically, it has all the same authority as whatever border official acted in the first place. And to alter or reverse, modify the decision that's being appealed for a board of 5 members, which you are, it takes a vote of at least 4 members. And that's 4 members regardless of how many members are present and voting. So even if only 3 members are present, you need 4 to overturn or modify the decision. Doesn't mean you can't take a vote, and you should, especially if you're up against the deadline, but it means that no matter what vote you have is going to end up being a denial. So in those circumstances, any sane applicant is going to agree to give you that extension, but you want to make sure you get it in writing before you continue. And trust me, I've seen situations where the applicant asks for a continuance, it's on tape, but there's no written agreement to extend the deadline, and the appeal is deemed to be constructively approved. Another thing to consider is the standing of the person appealing. So if the appeal is filed by someone other than an original applicant, say it's an abutter, or say it's not an abutter, it's someone who lives, 2 blocks away, the ZBA does have the authority to consider whether or not that person has standing, because you need standing to appeal, to file an administrative appeal with the ZBA. And standing means, are you going to be harmed in some way that's substantial and different from the community as a whole? The idea is not that you're sort of stepping in as, the enforcer of the law for the public good. You have to be defending your personal interests, which you have reason to think are going to be impacted in a way different from the community as a whole. And then the last bullet point here may seem pretty obvious, but believe me when I say I've seen a lot of decisions where there's no reference made and no apparent consideration given to the actual standards that should be giving rise to the appeal. So what specifically, if a abutter claims that the building permit shouldn't have been issued, on what basis? Are they claiming the building's too tall? Are they applying the correct definition of building height? Make sure that instead of just sort of making a qualitative determination about whether you think it's a good project or a bad project, you're actually looking at and citing to and basing your decision on the criteria and the standards that are in the ordinance or in the statute, if it's an appeal based on a statutory issue.
Jonathan,
Yes.
for the factors, that's the responsibility of the person bringing the appeal, correct?
Well, the person bringing the appeal should be expected to provide a valid basis for the appeal.
Okay, I want to make sure we're not the ones doing research on almost, if I were to look at it and say incomplete paperwork.
Yeah. I mean, you don't want to just reject an appeal or any application necessarily because it's incomplete. You want to make sure sometimes you only get one opportunity to act. That being said, absolutely, whoever is challenging a decision bears the burden of articulating how that decision is erroneous and is inconsistent with the ordinance or state law. And if they can't provide that basis, then you're not expected to sort of scour the ordinance and look for any possible way in which the development could conceivably be inconsistent with some standard in the ordinance. So yes, they should be pointing you to what they think are the reasons that the decision was wrong, and you should be making a determination as to whether or not you agree.
Okay, and I mean, that goes back to somebody having standing.
Yeah, I mean, they're usually connected.
Yeah. Okay.
Case law is actually inconsistent as to whether or not your standing has to derive specifically from the error that you identify.
Okay.
The standing is based on, will the project have a negative impact on your legally protected right? Judges have been inconsistent about whether the standing has to relate specifically to what you say was done wrong. So for instance, you might say, hey, this project is gonna cast shadows on my backyard, but the error that you're identifying is that it's too close to the front setback, which may not have anything to do with those shadows. it's actually unclear whether you have to connect those dots, but it's certainly something that can be raised and discussed by the board.
Okay, thank you.
Mm-hmm. All right, so the variance process, basically the same timelines, same required vote. Again, note that use variances are no longer allowed. A variance lapses if it's not exercised within a year. An appeal obviously delays that 1 year starting to run. And what constitutes exercising a variance, again, is like everything else in the law. There is litigation. There are a few decisions, but not a whole bunch. Here's what I can tell you: at a minimum, the variance has to be recorded within that year, and there has to be some action taken in reliance on the variance that significantly changes the applicant's position. So it doesn't necessarily have to be pulling a building permit and commencing construction. It could be closing on a property that you had under agreement and demolishing the building that was there. Again, there isn't a bright line test of what constitutes exercising the variance, other than at a minimum, it has to be recorded within that year. And the ZBA has the authority to extend it by up to 6 months. The request for the extension has to come in prior to that 1 year expiring. So and this sort of brings me back to something that I see really honored in the breach, particularly in a lot of communities that have old, out-of-date zoning codes, where a lot of the variances that are issued may not actually satisfy the statutory criteria. And that sort of happens over time, again, because there really isn't any way for good projects that the community likes to be developed without doing it through variances, and strictly applying the variance criteria wouldn't allow those variances to be issued. And so hopefully where we are now after this recodification is you're not going to be put in the position of people saying, look, the only way to make any, use of this property that makes any sense is for you to give me a variance. Hopefully the zoning ordinance now allows people to develop their property in a logical way and comply with the ordinance and not require a variance. That being said, there's still going to be variance applications, and there may still be applications that satisfy these criteria. And so here's what they are. First of all, there have to be characteristics regarding the conditions, soil conditions, shape, or topography of the land, or any circumstance relating to an existing structure that's unique and that doesn't generally affect other properties in the zoning district. Doesn't mean it can't affect, that there can't be any other properties that share similar circumstances, but it means that generally the land in the zoning district isn't affected by the same thing. So for instance, if you're in a watershed protection district, you're going to have a hard time demonstrating that your soil conditions are unique because they're within the same zone 2 of the same drinking water supply that every other property in the district is in. Then there has to be a causal connection between those especially affecting circumstances and a hardship that would make strict enforcement of the zoning ordinance result in an undue hardship with respect to the property. And it has to be, what the courts have said is the hardship is related to how the zoning ordinance interacts with the property. It's not a personal hardship. It's not, I'm a classical pianist and so I need this, special room to add on to my property with soundproofing, and the only place to put it is within the setback. It has to be more generally something that the board determines affects the property as opposed to the applicant. And then the third element is that granting the relief that's requested isn't going to result in a substantial detriment to the public good or substantially nullify or derogate from the intent of the ordinance. So again, a lot of times applicants don't really make a case for how they satisfy these criteria. And in a lot of communities, I see boards not really strictly enforce them for the reasons that I already went over. Now, hopefully, again, you're going to have an ordinance that can reasonably be enforced and that the variance can go back to being what was intended, which was the rare exception to the rule. The board, of course, if it does grant a variance, can impose reasonable conditions. And a little bit later in the presentation, I'll get into discussing what some of those conditions can look like. So the special permit process, when the board is the special permit granting authority, is different from this process for variances and appeals. Same 65-day deadline to open a public hearing, but rather than having a deadline of 114 days from application to act, a special permit decision has to be filed within 90 days after the hearing closes. So there isn't actually a hard and fast deadline. It's always based on when the board decides to close the public hearing. So you might continue a public hearing for 3 months to allow an applicant to provide a traffic study or some other information. And you're not going to, in that circumstance, you're not going to be in danger of constructively approving the special permit because the public hearing is still open. The required vote is the same, 4 members out of a 5-member board. And then this is one change from the prior version of the ordinance, is that to reflect a change in state law that happened about 10 years ago or so, that allowed the deadline for exercising a special permit to be extended from 2 to 3 years. The ordinance now includes that 3-year deadline to exercise a variance instead of 2 years, which is what the prior ordinance said. And that deadline is except for good cause. And the good cause doesn't have to be demonstrated before the deadline runs, but any smart applicant or property owner is going to come in and make sure the ZBA agrees that there's good cause if they're not able to exercise their special permit within that 3 years, instead of just sort of making the case at some point after the 3 years has expired. One other difference from a variance is that a special permit can be exercised even while there's an appeal pending. So if an abutter appeals the grant of a special permit, the applicant has the right to exercise that special permit. You often see that when it's a special permit for a use. Less likely to see it when it involves construction of a building, because you're really exposing yourself to some significant expense and financial loss if you build a building at risk of having it ordered torn down afterwards, and I have seen that happen. So the special permit decision, less so for the ZBA than the council under the ordinance, since most of what you're going to be doing by way of special permit is with respect to nonconformities. But it's always very important to, again, look at the specific findings that are required under the ordinance, the specific criteria for granting a special permit. That's the sort of thing that changes based on the way the zoning ordinance is written, whereas a zoning variance is going to be the same standard under state law no matter what. So very important to make sure that you have the applicant present proposed findings, or at least a narrative of how they argue that they are satisfying all the requirements of the ordinance. And again, you can impose reasonable conditions. Unlike variances, a special permit can, when it's appropriate, be conditioned and limited to a specific applicant or a specific business tenant, whereas a variance runs with the land no matter what. All right. Before I hop into nonconformities, which is pretty big subject, any questions that I haven't seen? All right. So nonconformities break down in a number of different ways: by structure and by use, by lot, and by different types of structure and use. So I'm going to run through a little bit some of the different types of nonconformities, structures, uses, the special rules that apply to 1, 2, and Lynn 3-family structures, vacant lots for 1 and 2 family dwellings, and then I'm going to briefly touch on the merger doctrine and a recent change to the State Zoning Act that is unlikely, frankly, to have a lot of significance in Lynn, but I'll touch on it anyway, briefly. So the burden is on an applicant to demonstrate that the structure or use that they're asking to alter is actually lawfully pre-existing. For a structure, they can demonstrate that either by showing that the structure predates the zoning ordinance provision that the structure doesn't comply with, or that the structure with that nonconformity has been in existence for 10 years or more without the city taking zoning enforcement action. So once 10 years goes by and a structure, even if it was built without a building permit, even if it was built in violation of the building permit too close to a setback, 10 years goes by, it's now considered to be a lawfully pre-existing non-conforming structure. A use, in contrast, has to predate zoning for it to be lawfully non-conforming. So even if you open a corner store 40 years ago, if it wasn't a lawful use when you opened it, it never becomes a lawful use.
Ask about the distinction between the use and structure variances that would be needed. So if you propose to change, let's say, use, do you then also have to get a finding in regards to the nonconformities that pre-existed with the building as well, or do you just have to do it as to the thing that you're proposing you change?
It depends. So in general, if you have a pre-existing non-conforming use in a conforming structure, then, and you want to change or extend that use, but you're not going to result in any structural nonconformity, then all you need is a special permit to change or alter or extend the pre-existing nonconforming use. If you have a pre-existing nonconforming use that's happening in a pre-existing nonconforming structure, and you want to substantially change that use, then it's kind of a distinction without a difference, unless you're going to be enlarging the structure or extending the structure as well. But if you're just changing the use either within the non-conforming structure or maybe on the lot but not changing the structure, then really you're just seeking relief to extend the non-conforming use. If you're enlarging the structure itself, then yes, you would also need to make sure that in your application you're asking for permission to extend or alter the pre-existing non-conforming structure. Unless it's a 1, 2, or 3 family structure, and I'll get into this in a few minutes. If you're changing the 1, 2, or 3 family structure, but you're not making it more non-conforming, then you would not need relief for that alteration of the structure, although you may need relief for the use if the use is not allowed in the district.
Thanks.
And then finally, a lot that predates zoning and hasn't been held in common ownership may qualify under what's called the single lot exemption. Again, in Lynn, I suspect that although the requirements to qualify for that exemption probably aren't difficult in, say, Concord, they're probably going to be difficult to satisfy in Lynn because the requirements are that the lot have at least 5,000 square feet of area and at least 50 feet of frontage. If a lot satisfies those two requirements and is vacant, then it's protected and it can be developed with a 1 or 2 family structure if the use is allowed in the district. That requirement that it be held in common ownership at all times since it became non-conforming was recently modified a little bit by the legislature to provide that a lot with 10,000 square feet of area and 75 feet of frontage can have been held in common ownership with adjoining land. It's exempt from this merger doctrine, but you can only build a house with up to 1,850 square feet, and it can only have 3 bedrooms, and it can't be used for short-term rental use. Again, I very much doubt that there are a lot of vacant 10,000 square foot lots hanging around in Lynn, but I thought I would mention that the statute had been changed. So it does come up, it's in the ordinance that if a use has been abandoned or discontinued for a period of at least 2 years, the non-conforming protection can be lost. The difference between abandonment is, there's some actual intent to permanently end the non-conformity. So you tear down the non-conforming structure and don't apply for a building permit to reconstruct it. You give up your Citgo gas station franchise and don't renew your fuel storage tank license. You take some action or inaction that makes it clear that you're not intending to preserve that non-conforming use protection. In contrast, discontinuance doesn't have anything to do with your subjective intent. It just has to do with whether or not you've stopped exercising that non-conforming protection for a period of 2 years or more. Now, as Aaron mentioned, one thing that has been added to the ordinance is that the city council, and this is the one thing regarding zoning nonconformities that is a city council determination, does have the ability to grant a special permit to resume a nonconformity that otherwise has been lost, discontinued, or abandoned. So with respect to 1, 2, and 3 family structures, I touched on this briefly, but those structures have special protection, and a special rule governs those types of structures being modified, which is that if someone is modifying it in a way that doesn't increase the non-conforming nature of the structure, no special permits required. That's something that's allowed by right. If the non-conforming nature is going to be increased, say, an addition that goes further into the non-conforming setback, then that still would require a special permit. And I see Ibrahim has a question.
Oh, it was about the previous slide.
Sure.
So abandonment or discontinuance, an applicant wants to resume it, it goes to City Council. Under that specific scenario, City Council will also be in charge of deliberating, determining on any of the structural nonconformities of the actual structure? Or does that have to be discussed by ZBA if that's a relevant factor?
Yeah, I mean, if the proposal is, the example I give is you have a corner store, pre-existing non-conforming use in a residential neighborhood. It was there for decades. The owners die. The kids don't have any interest in continuing it. The property's caught up in probate for 3 years. Finally, someone buys it and says, hey, I really want to start this up again as a corner store. They're not looking to do anything different from what it was before. It's just that more than 2 years has gone by, and so the use protection has been lost. That's the sort of thing the council would have the authority to allow it to resume by special permit. If they then wanted to, expand that corner store into an adjoining property or onto another part of the property that wasn't previously used, that would still be something that would require a special permit from the board, from the ZBA.
Okay.
So unlike 1, 2, and 3 family structures, any alteration of other types of structures, even if it doesn't increase the non-conforming nature of the structure, still has to be approved by special permit. It's the same standard, whether or not it's going to be substantially more detrimental to the neighborhood. Again, any creation of a new nonconformity is still going to require variance. So you have a pre-existing nonconforming structure, it's too close to the side setback on the right, and they want to put an extension on to make it now nonconforming in the side setback on the left, that's a variance. If they just want to go further into the already nonconforming side setback on the right, that's a special permit.
So can I just ask, if you do something that, let's say on the left half of the building, you are still within the setback, on the right you're not, it's non-conforming. You build on the left half, which was conforming, up to the point where it would still be within the bounds of the zoning code. Would that wipe away the pre-existing nature of everything and they'd have to redo all of it, or would they still be able to do that by right without any relief?
So for a 1, 2, or 3 family, they'd be allowed to do that by right because it's not making the structure more non-conforming. For any other type of structure, that's going to require a special permit, even if it has nothing to do with the existing nonconformity. Putting a dormer in or changing your windows or something isn't going to trigger that, but anything that is a significant structural change to the building is going to require a special permit for those non 1, 2, or 3 family non-conforming structures.
Just because of something that has nothing to do with the area that they want to build on, just because they're making a significant enough change that you need the special permit.
That's right. It's less likely to be deemed substantially more detrimental to the neighborhood in most instances, so it might be an easier lift to get a special permit, but it still requires one. And in Section 5E of the ordinance, it's been made clear that any reconstruction after a catastrophe or voluntary demolition has to commence within 3 years. So again, probably not something that's going to come before you, but just mention that. So here's the non-conforming lot exemption that I mentioned. I ran through it briefly. Again, I don't think it's likely to come up too often in Lynn. So unless people have questions about it, I'm going to skip over these. Changes to non-conforming use are a little bit more complicated than to structures. So the ZBA has the authority under the ordinance to approve a change from one non-conforming use to another, or an extension of the non-conforming use. And whether that is necessary or it is subject to this three-part test, right? So if you have a pre-existing non-conforming restaurant and you add more tables, that's not necessarily an extension or alteration of the pre-existing non-conforming use that's going to require a special permit. So under what circumstances will the court say that a special permit's required? Well, you have to look at these three factors that the courts have laid out. The first is, does the proposed use reflect the nature and purpose of the pre-existing non-conforming use? So are you taking what was a convenience store that also sold beer and you're turning it into a full liquor store that sells wine and liquor? You could argue that is not reflecting the nature and purpose of the pre-existing non-conforming use that was already there. Is there a difference in the quality or character as well as the degree of the use? So I've never seen a judge who's been able to really clarify how those first two factors are different, except to say that the second factor is a combination both of the nature of the use that's being proposed and the degree of the use. So are you going from, a truck stop that sold diesel, to 3 or 4 trucks a day to a full gas service station that, you're now changing the type of fuel you're selling, but you're also going to be serving 10 times the number of customers? Yeah, you're probably going to trigger that type of this factor. And the third, which is the one that I think most often is the focus of these types of questions, is the use different in the kind in its effect on the neighborhood? So it's not just, are you having more cars come by, so it's, more traffic, but it's the same type of impact on the neighborhood? It's, are you now extending your hours and adding, you were a restaurant, now you're a restaurant with live music that goes further into the night, so that now you have a lot of, additional noise on the neighborhood that wasn't part of the pre-existing non-conforming use. So if a project or a proposal changes the pre-existing non-conforming use in any one of these ways, then a special permit is required, and the standard is the same. Is it going to be substantially more detrimental to the neighborhood? If it's not, none of these factors are triggered, then no special permit's required, and no relief is required. Usually how this question comes before a ZBA is that someone complains about a pre-existing non-conforming use, it's under new ownership, it's being run in a different way, and the building official has to make a decision about whether or not those changes trigger the need for a special permit. Maybe the building official says yes, issues a cease and desist order, and says you need a special permit before you can keep doing this. The applicant or the property owner is most likely going to file an application that both appeals from that decision and in the alternative asks you for the special permit. So that's usually how you see these things come up.
Yeah, I was just going to ask that question, Jonathan. So just to be clear, this is generally speaking, this determination, this 3-part test will be carried out by the Inspectional Services Department. And if it's deemed that they do need a special permit, then it comes to the Zoning Board of Appeals. But there may be a case where the building commissioner makes a determination and the applicant may appeal that to the ZBA as an administrative review, right? That's where you might, the board may get involved with this kind of analysis.
Exactly. And I'll say that my experience, this is one of the areas that is sort of the most frequent source of appeals, because you have a open parking lot that's been used for as a bus, to park school buses after school. And every once in a while, maybe you'll have a bus coming and going from a trip or an away game or something at night. But for the most part, it's during business hours. Then someone buys it and now it's, a contractor yard, or it's a company that does landscaping and snow plowing, and, neighbors start to complain. It's often not a really easy decision whether or not this, one of these factors has been triggered to require a special permit. And any applicant or any property owner or business owner that gets a determination, a zoning enforcement letter saying, hey, you need a special permit, they're crazy if they don't both apply for the special permit and appeal that decision and say, wait a minute, we don't think we trigger this. Where we have fewer vehicles we're parking there, we're not substantially changing the hours, and it becomes a very, very fact-specific decision that the highly paid members of the Zoning Board of Appeals get hazard duty to have to make that decision.
So on a practical level, if we encounter these scenarios on special permits, non-conforming uses, we will have to essentially take 2 votes, one determining on the applicant's appeal on the nature, and then having another vote on the merits, on how the special permit will be granted, the details of it, etc.
Yeah, that is a great point. If you get an application like that has both an appeal and a special permit, you want to keep a few things in mind. First of all, they're on different timelines. The appeal has to be decided within 114 days, and that decision has to be filed within 114 days of the application. The special permit decision doesn't have to be issued until 90 days after the public hearing closes. Usually an applicant is going to be willing to sign an extension agreement to put them on the same track so that the public hearing can happen at the same time, unless the board decides it wants to sort of bifurcate the issues, make a decision on the appeal first, and then if necessary reach the special permit. If the appeal is if the decision that a special permit is required is overturned, then the applicant's almost certainly going to be willing to withdraw the special permit application and you never have to get there. So it's usually going to be a little bit of a conversation, maybe between staff and the applicant's representatives, or at the initial public hearing. But if you do end up having to make the decision on both, then I would recommend doing it as 2 separate votes. They may throw in a variance appeal for good measure if it's unclear whether or not it's something that the ZBA could approve by special permit.
Great.
So Jonathan, not that this is an actual case, I'm just trying to understand. If there's a historical, if we go back to your example of it being a school bus lot and now it's a different lot, is there going to be a requirement of posted hours of the past use and then posted hours of a current use? That, I mean, how do you distinguish something like that where there's a tracked history?
Yeah.
And is that not our concern that somebody else is going to give us their findings and we just have to analyze the findings?
Yeah, so it becomes a little bit of a detective process. You can absolutely ask the applicant to provide any information and documentation they have of the historic extent of the use. That could be hours, it could be how much of the property was, actually used in this way. It can be how many vehicles or customers or widgets they were selling. You're basically just trying to gather all the information to understand the historic use, and then all the same information about the extent of the new use, whether it's an existing use that is the subject of enforcement or a proposed use where someone comes in for permission instead of forgiveness. And then you can ask for any information you want from the applicant. You can ask for it from city staff. You can ask for it from the neighbors who are showing up at the hearing. Basically, any evidence that comes in front of you is going to be part of the totality of the information that you're going to make your decision on. And it's not always going to be a really easy decision. And judges are not supposed to substitute their judgment for the ZBA for that exact reason. A tie or even a close call is decided in favor of the ZBA's decision. So all you can do is your best, and sometimes they're really tough decisions to make. And sometimes these hearings can go on for 3, 4, 5 hearing sessions so that the board can get all the information it can to make the best decision it can.
Thank you.
Sure. So I want to briefly just cover public hearing process. I want to start by saying there's no right or wrong way to do it. There's no right or wrong way or order of presentation. This is sort of a roadmap of a process that I have found is helpful, but I also know that every board has its traditions and its sort of normal process, and I'm in no way suggesting that this is the only way to do it. One thing is absolutely required, that you have to comply with both the notice and publication requirements of the Zoning Act and the posting requirements of the open meeting law. So those are the first 2 bullet points. Generally, I think it makes sense for the applicant to go first, explain the nature of what they're asking for, what kind of relief, how they satisfy the standards, give a little an overview of what they're proposing. Some boards like to have board questions and comments first. Some boards like to have public comment first. A lot of times boards will decide that they want to go after public comment because then they've had the benefit of hearing the issues that are of concern to neighbors. There's also no reason you can't have board comments and questions, then public comment, then more board comments and questions. It's real. There's no right or wrong way of doing it. It's just making sure to outline how things are going to run, so people, particularly in the audience, have an understanding of when they're going to be able to have their say. If there are a lot of people present or on Zoom or whatever the case may be, the chair is certainly allowed to set reasonable time limits, make sure that people only speak once or can't speak a second time unless everyone else has had an opportunity to speak once. Just understand that you never get into trouble for giving people too much due process. Sometimes you can get into trouble for cutting people off, even if it seems like they're repeating themselves or what other people have said or speaking to something that's irrelevant. Certainly fine to say, hey, look, I know that you're really concerned about noise, but that's not one of the criteria the ordinance tells us we should be looking at. I'm not going to tell you you can't talk about that, but you may be better served to speak to the issues that we're supposed to be actually looking at under the ordinance. If you're going to continue a public hearing, you're not going to close it, then extremely important to make sure that you vote to continue it to a specific date. You can't vote, a motion to continue to our next meeting isn't going to work. Has to be motion to continue to our meeting on September 9th at 7 p.m. in, the council meeting chamber or whatever the case may be, or by Zoom, just that you have to make sure that the vote is specific about when and where the public hearing is going to be resumed. If you don't do that, then you have to republish and renotice at the public hearing and start all over again, lose those 2 weeks or more based on having to redo that. So definitely want to remember to make sure that any continuance is specific. If you're not going to continue the public hearing, you want to vote to close the public hearing. That means no more evidence can come in. That means no more evidence from the public, no more evidence from the applicant, no more evidence from city officials. Doesn't mean that, say, Aaron or someone from planning can't discuss standards with you and, go through the evidence that has already been submitted, but you can't then have, DPW provide you with new, new information about adequacy of sewer service to the property.
How to distinguish between the public and the applicant in how you deal with these public hearings? So can you say request more information from the applicant, but not reopen up a bunch of? I know that that's kind of a specific example, but
yeah.
Are you permitted to treat the public differently than the applicant, I guess?
So overall, the answer is no. If, for example, if the board is asking the applicant, hey, it really seems like this building is too tall. Can you go back and bring us, look at options, look at ways maybe to reduce the peak of the roof or whatever the case may be, bring us new plans. You can't then close the public hearing to everyone except the applicant. The public is going to want and be entitled to an opportunity to review and speak to those new plans. If if you say to the applicant, look, we're going to close the public hearing, but we want to tell you that we have a concern about the height of the building, and you may want to think about whether you would agree to a condition to reduce the height from 40 feet to 35 feet. And you're really just waiting for the applicant to say yes or no. Well, you can do that, and then the public can be heard that same evening on that issue. And there's really no new information that's going to come in that the public's going to, have a basis to say, hey, look, if we had known that was going to be part of the proposal or part of the decision, we would have been able to speak to it because they would have had that opportunity. It all comes down to a question of, is anyone in the public being deprived of the opportunity to speak or weigh in on evidence or information that the applicant had the ability to, but they didn't? It really comes down to sort of fairness and process. It's not always crystal clear, and I would say when you're in doubt, keep the public hearing open and let the public have a say.
Thank you.
With that said, Jonathan, if we're requesting information, I would imagine that if we're requesting additional information, either revised drawings or additional reports, whatever it is, that we would ask the applicant, how much time they need to prepare for it before we determine what the next date, time, and everything else would be.
Yeah, usually it's a discussion along those lines. 2 weeks probably isn't going to be sufficient time for the applicant to go back and have their architect prepare new building plan, new elevations showing some significant change. So you look at your schedule, you talk about when you're going to continue it to. If they end up needing more time, you can always continue it again. You can always continue to another date certain if they're not ready. Again, just make sure that you're keeping track of the deadlines and getting them to sign any extension agreements that are necessary so that you don't get jammed up.
Thank you.
Sure. So once you do close the public hearing, you want to, first of all, make sure who's eligible to vote. And you've probably heard of the Mullen Rule, the idea that you can only vote as a board member on an application that you have personally been present for every hearing session, or if you can miss one single hearing session if you either review a video or an audio recording, or the statute says a transcript, but relatively detailed minutes are almost certainly going to suffice. And then you have to sign a certification that you've done that before the vote takes place, and then that will allow you to vote. But again, it has to be no more than one hearing session. You have to have reviewed that recording or transcript or minutes prior to the vote, and you have to sign the certification prior to the vote. And then I always recommend that the motion to approve or not approve, usually motions are phrased in the affirmative as a vote to approve, because it's clear if you don't get those 4 votes, then the motion has failed. I always recommend that the motion either include, at least broadly, the findings and conditions that are going to be included, or if there's a document or even a recent discussion that's going to be reflected in the minutes of the recording of what the basis for the motion is. But if you close the public hearing and then just vote to approve, there's really no record of the reasons that the board voted to approve that application. So at least during deliberations, discuss it. Yeah, I think this is a reasonable application. They've done what they can to limit the impacts on the neighbors. They got rid of the windows on the right side of the building, so they won't be looking out over the neighbor's backyard. I really don't think it's going to be substantially more detrimental. They've really tried to keep as much as possible outside of the setback, whatever it is, so that the record provides a basis for defending that decision if it were ever to be appealed. And then the decision should reflect those findings and the conditions that are stated. And I'll get to conditions in a little more specificity in a minute. Something that comes up a lot is site visits, and I don't know if it's something that the ZBA has done a lot of or not as a group. There's nothing at all to prevent members of the board individually from going and viewing the site, as long as it's not posted no trespassing. of a application. But if the board wants to do it as a group, it's actually exempt from the posting and other requirements of the open meeting law, as long as the members of the board don't deliberate, don't discuss the application, don't discuss what they see. They're just walking around and sort of taking note of what they want to take note of. It can sometimes be difficult to tell that, at what point just sort of general comments turn into deliberations. And so it's something to be careful of. You can post it as a public meeting, and then you don't have to worry about that. You can deliberate, but that raises other issues such as ADA compliance for the public to be able to attend and getting the permission of the applicant for the public to go on their property. So, again, it's going to be a case-by-case decision on what makes the most sense, but these are just some of the issues to be aware of. Something that a lot of boards don't take advantage of as much as they could and may benefit from is the ability to require applicants to fund hiring outside consultants. So if there's a concern about the massing of a proposed extension of a pre-existing non-conforming structure, the board can hire an architect and require the applicant to pay for that architect to take a look at the plans and make recommendations on the impacts it would have, how it could be made less detrimental to the neighborhood, whatever the case may be. So the board does have the authority to do that. It would have to adopt, if it hasn't already, a rule. No public hearings required for that. And I've mentioned to Aaron and promised to provide him with one. I think I haven't yet. So there's a good reminder to provide him with a form of what that rule can look like. And you would just have to put that on your agenda at a regularly posted meeting is something that you're going to take up. And it can be a really useful tool because sometimes there are not city employees either with the expertise or the bandwidth to provide that sort of support. And the board might feel that it could really benefit from having it. And so that is a tool that's available to you. That can be appealed to the city council, but the appeal is actually limited to two issues, either a conflict of interest of the consultant who the board chooses or lack of sufficient qualifications. It does not include, hey, we don't want to pay for this and we don't think the board needs it. So just something to be aware of. And then once oh, sorry, go ahead.
Just in terms of how this happens procedurally, if the board determines that this might be an option to pursue for any given application, does this happen once the public hearing is open and we at least have heard the initial comments from the applicant? Can this happen before or
it can happen before. So some boards have adopted rules that basically say, as part of their fee structure, you're going to make a deposit of $2,000 with your application for certain classes of applications. If we don't use it, you get it back. If we do use it, we're going to make a decision at the initial public hearing session. Some boards have voted to authorize staff to sort of get that process rolling so you don't have to wait for the first public hearing session. For a lot of times you'll see this, for projects that trigger certain thresholds, it's just standard that the board is going to require a traffic study and require funds to peer review to hire a consultant to peer review the traffic study. And so rather than have the delay of waiting for notice and advertisement in the first public hearing to get that ball rolling, it's just sort of a standard process to have the applicant put the money up front. It's to their benefit. They'd rather get it started earlier. I tend to doubt that's something that is going to be sort of a standard need of the board. And so I think most likely, yes, you would open the public hearing if there's something that makes you say, look, this is a really complicated application in this particular area, and we want to get some advice from a consultant. So I move to have the applicant fund, an engineer or a acoustical engineer to help give us information, guidance on the noise impacts of this proposal. And, we authorize the chair to retain, to engage with an engineer and get requests, get a proposal. That's usually how I think it would likely happen with you. But you can come up with a process that works best for the board, and after you've had a few different experiences and seen, the pros and cons of different processes.
Great.
So,
Aaron, just real quick, has the board ever done this? At least to my knowledge, since being on the board, I haven't seen this.
I'm not aware of the zoning board or the city council, I think, for that matter, seeking 53G funding. I'm not even sure that's been authorized by the zoning board at this point.
I mean, we have asked applicants to provide sort of an engineered information to supplement their application, like traffic studies and that type of stuff. But we didn't provide the independent reviews. The only thing I'm thinking is for some larger applications where we have the stormwater aspect of it, that may need to be engineered. And if it's a more complicated structure, we may need to have somebody with that expertise review those types of applications where it's very engineered to, what on the percentage allowed, and there may be calculations to mitigate that, and processes to mitigate that, whether it's groundwater recharge or recharging it into the ground, porous pavements, whatever they can do to meet that requirement. So that might be a case where this may come up, and I'm thinking more in that arena than anywhere else under the new regulations.
And just to piggyback on that, the Conservation Commission in Lynn does frequently require an applicant to pay for an independent expert the city's choosing.
Yeah, they have a similar thing with the stormwater relative to the wetlands, but where under new zoning regulations there'll be properties that aren't under a notice of intent environmental regulation, but now they suddenly need to be doing stormwater calcs to make sure they meet the requirement for that.
Yep.
So with that information, because that could get into a process of trying to find professionals that, if they're going to be able to lend their time to it. And so if things are going to be on a clock, is it something that, if that's going to be something to be engaged on the road, that we actually put out through the city, something for like engineers and architects or professionals to get pre-approved, that there's actually like a pool of resources?
Yeah, I mean, I've seen it done that way. I've also seen city engineers do it, or departments, and if they don't have the capacity at the moment, then they end up being somebody that you would hire in that manner, where they'd be on call for a period of years, right, to do independent reviews. I've seen it done for conservation, to for wetland delineation, to go out and verify that the delineation was done correctly. So you might have somebody go out under that. And then, usually it's like over a period of time, they would provide that independent review. You'd get a retainer from the applicant and they would be paid from that, the whoever's doing that independent review would be paid from that deposit.
So
Yeah,
I'm
that's an
assuming
example
that
of where
unless there's a standing contract by any one department that already has engineering services on call, and
Yep.
it has to be RFQ'd or any other type of municipal procurement process, then most likely we would need to have the applicant sign the waiver for the timelines, so that there's that leeway if it takes X amount of time and we're under pressure. Is that something that usually happens that you've seen, Jonathan?
So most of the types of consultants you'd be looking to hire are actually exempt from all of the procurement requirements of Chapter 30B.
Okay.
Architects, planners, accountants, engineers, attorneys.
Lawyers.
Yeah, are all exempt from Chapter 30B. So now sometimes, and I haven't checked the city's general ordinances. Sometimes there are general bylaws and ordinances that impose certain types of procurement requirements that are more stringent.
We do not have those.
Okay, so there would be no public bidding requirements for this, and I will say that most of these types of consultants are used to providing peer review services. So most engineering firms that provide peer review are used to getting contacted and told, look, we have an application, we have a public hearing, we have to close it within 3 months. Do you have the availability to provide peer review services on these issues? And it's not, there are a lot of boards that do this really frequently, and there are a lot of firms that are used to it. So I know it's sort of a new concept for you, but I don't think you'll have a lot of trouble if it does come up and you do want to hire a consultant. I think you'll be able to find people, especially with assistance from Aaron and his team. I'm volunteering you to identify some of the common firms that are in this field. You should be able to find folks to help you out.
So not to stick my neck out, but I'm not licensed in the state of Massachusetts, but I am an architect. So I typically have to do this. I should avoid. I mean, as you were saying, most boards don't have professionals on the boards. If I'm reviewing drawings for residential, it's not an issue because I'm not licensed in Massachusetts. I can't claim to be an architect for commercial properties.
Yeah, but I'm
used to doing exactly what you're talking about. It's looking at the ordinance and everything else and making sure it's in compliance or doing it for my clients as opposed to this side of it.
Yeah, so you're members of public boards. One of the benefits and the whole idea is that you're bringing your knowledge and expertise and familiarity with issues in the city to the board. You're not expected to forget what you know.
Right.
So you're an architect, you have that knowledge, you're not stamping plans, you're not preparing plans, you're not telling anyone that you're acting in your capacity as an architect, but you're a member of a board that has certain understanding of the concepts. You may decide, I feel pretty comfortable making, some conclusions or findings or suggestions. I don't feel like we need to hire an architect, up to the rest of the board members, but I feel like I can weigh in on this. Absolutely fine, but if you do decide that you want to have someone peer review, the claim is that the requirements of the Architectural Access Board in Massachusetts, as opposed to the ADA, are, imposing some requirement that creates a hardship that supports a variance, and you're not comfortable weighing in on that because it's not a field you've practiced in Massachusetts, and you want an outside architect, that's fine too.
Okay. All right. That's fine. That's actually where I'm most comfortable, is actually in healthcare. So it's like, I know exactly what you just referenced.
So I just see this as, a lot of these may be simple if it's just, a single house and they're doing some simple calculations. But if it's a more complicated, development, we may need an independent review of those types of calculations. It isn't just a tabletop, there's might be a software involved that they use to do these calculations. So there we may want, I would probably reach out to like the conservation to say, who do they use for stormwater evaluations, right? That they typically use for independent reviews. The planning board may have some other ones that they use. But I just see this as a rare thing when something gets a little bit more in depth than just reviewing, and it does need some independent review. Then that resource will be there. But the stormwater one just jumped out at me as one that could trigger that.
Well, the stormwater is a unique analysis. And some for the older, more veteran members of the zoning board with respect to the greenhouse, that there was a zoning board petition to turn it into maybe a convenience store. I think the zoning board asked that they do a traffic study. I think it might be better for the zoning board to hire a traffic study rather than the applicant, because the applicant's paying for the study that is ultimately going to come in. And it may turn out that the greenhouse and the florist shop is going to come out the same as a convenience store, but it's a unique opportunity that being presented to you guys tonight.
No, I agree with you, Jim. I think that would be something that would be very useful to the board, and it would be independent. I was going to suggest the same thing.
Yeah, typically those are done as independent reviews rather than doing it for the client, where they submit the information. In other words, under the zoning regulation now, the stormwater is a calculation that's going to be required for all these applications. And if it gets more complicated, they submit the calculation. It may, I'm an engineer, I could probably figure it out, but I'm volunteering my time on the board. I'm not there to analyze all the calculations. Did they do it right? All I can see is they did it. I need somebody to go at it and look at it a little more in depth. Did they do the right thing? And is there any concerns or comments based on what they did? And that's what the independent review does, is review the submittal. And did they do it in accordance to what the zoning regs say?
So to that point, usually, the law doesn't require it to be done this way, but usually what happens is the applicant will submit the drainage calcs or the traffic impact assessment or the architectural elevations, and the board will hire a consultant to peer review that, to look at, were the proper standards followed? Were the right, information? Was the correct, storm event used, and whatever the case may be.
Yep.
And then are the conclusions based upon, a correct analysis? You're not usually going to be hiring someone to conduct a new traffic study. You're going to be hiring someone to look at how the traffic study was conducted. But the other side of it is, even if they agree with all of the methodologies used by the applicant's expert, the other, really useful piece of having an outside consultant sometime can be to suggest recommended conditions that can, help to mitigate impacts on neighbors or public services, or just make the project better. If someone's asking for a special permit, it might be that it can just, different landscaping in a different place. If you have a landscape peer reviewer, you don't want to plant that type of tree you want to plant this type of tree here. It's going to live longer. It's going to, be much more beneficial to the community, whatever the case might be. So it can be a very useful tool. Not saying you need to use it on every application by any means, but just something to be aware of.
I just want to be conscious of time, but the last question that I had probably for Jim, and in relation to this, so does this have to be in explicit writing through board regulations, or is this something that can already be asked for? And if so, alluding to the comments about not doing it for every applicant, etc., have other boards developed a form or a set of parameters, thresholds that would trigger or would allow us or guide us? It's not the same as a single family, 2-family, 3-family applicant who is coming without a lawyer and was coming without too much of that support that you maybe see with applicants with a lot more resources. So also keeping in mind to try to be fair from that standpoint, since it's the heavy lift financially for a lot of folks.
It does require adoption of a rule.
Loaded question. I'm lucky enough to be on a call with one of the best zoning lawyers in the Commonwealth. I do believe that my brother brought up force the applicants to explain why you're entitled to a special permit and or a dimensional variance, and I think we should change the application where they spell out this is why I meet the standard, and then we can just copy it if in the event that the zoning board believes that they meet the standard. And I think that's a great first step. I don't know necessarily we treat someone without a lawyer differently than one with a lawyer, because the standard still is the same. But I will defer to my brother on that point.
Yeah. So a couple questions in there. One is, yes, you do need to adopt a rule, and I have promised Aaron I'm going to send him. I've developed a form, and basically you can sort of plug in and adopt it and tweak it as you see fit. So I've made another note to do that and get him that. And it doesn't require a public hearing by the board. It just has to be adopted at a regularly posted meeting, and it should be included on your agenda as something you'll be discussing. And then in terms of sort of preset standards on when you're going to require a consultant to be funded, I would recommend against that and really just do it on a case-by-case basis, because there might be a single family proposed that raises some unusual issue, and you do want to leave yourself that opportunity and flexibility to adopt or to retain a consultant. And there might be a large warehouse that really doesn't raise any issues that cause you to want to hire an outside consultant. So I would really just leave yourself as much flexibility as you need. And then again, as you start to, I don't know why things are appearing on my screen all of a sudden, as you need to hire them. And if you start to run up against deadlines, it really shouldn't become an issue with the applicant, because they know that if they say no, they're forcing you to vote based upon information that you don't feel is adequate to make an informed decision. And they're running the risk that the vote is going to not turn out in their favor on that basis.
Great.
I'm happy to stay as long as possible, but I do suspect people are starting to be ready to wrap it up. I just have a couple more slides. This is really a subject I already went over, just making sure that your decision has all the relevant information about the property, about the project, what findings are required under the ordinance or the statute, and how the specific facts support those findings. So for instance, a decision that just says the project won't be substantially more detrimental to the neighborhood, that's not really a finding. It's just parroting the legal standard. But saying it's not going to be substantially more detrimental because it's only 500 square feet and there's going to be adequate screening and it's small, the structure is still going to be smaller than most of the other residences in the neighborhood, that's explaining why you're determining it's not going to be substantially more detrimental to the neighborhood. And then just quickly on conditions, they have to be reasonable. They have to be related to intended to mitigate the impacts of the project, make the project better. But beyond that, the board has pretty broad discretion to impose conditions on either a special permit or a variance. One thing that I always like to point out is that you may have a long discussion with the applicant, and the applicant might answer a lot of questions that make you feel really comfortable with the project. But those answers have to find their way into conditions. Otherwise, it's not going to be enforceable as a condition. So you want to identify, you want to have a condition that says the project has to be built in substantial conformance with the plans, except, they're going to add a parking space here, or, list how it's going to deviate. It can also be useful. This goes to a question someone asked earlier. You don't want to have someone come back and have to apply for a special permit modification and for you to have to hold a new public hearing because they had proposed 3 dormers and instead they changed it to a single shed dormer. If you do want that to have to come back, fine. But if you don't, you may want to give some ideas of the types of minor changes that aren't going to trigger a requirement to come back. Mitigation requirements, again, should be proportional and related to the project. Don't make someone buy a fire truck. That's one I've seen more than once. Unless the project is triggering the need for another fire truck legitimately. And then back to consultant review, if you think that there's going to be a need, for instance, for an engineer to review as-built plans, I recommend putting that in the decision as a condition that the applicant's, going to have to fund that before they get a certificate of occupancy.
Did I read in an earlier slide that you said something that that it can't be a condition of a variance that there be continued ownership of the property, or did I misread that?
No, that's exactly right. That's a little counterintuitive. In the statute, it says that a variance cannot be conditioned on continued ownership by the applicant, whereas a special permit can. So you can say, for instance, we're going to give you a special permit for this restaurant, but it's specific to the applicant. And so if a new restaurant comes in, we want that new restaurant to come in and apply for their own special permit. That is legitimate. As long as it's, reasonable, it's not arbitrary and capricious. A variance cannot have a condition that is applicant specific. I don't know why this was put in the statute in 1973, but my guess would be that it goes back to what I mentioned, which is that the criteria for a variance have to do with how, whether there's a hardship specific to the property, not to the applicant, that's based on features of the property or features of the structure. And so it's really not an applicant specific standard that you're acting on. And so the legislature, I think, decided that it shouldn't be an applicant specific decision. And that brings us to the end. So I appreciate everyone sticking it out with me for just about 2 hours. I'm happy to stick around, answer any other questions people might have, or, if people think of things later, Aaron knows where to catch me. But I appreciate everyone's time.
Jonathan, I can throw one thing out there. The zoning board, it's unique. We have variances in 48-6 petitions. The city council controls special permits. So this is a unique thing for the zoning board. But really, how our new zone ordinance is written, 48-6 is now our section 5 of the zone ordinance. And it is a special permit. If you could explain that.
Yeah. And I think this also goes back to something we discussed at the beginning. I think over time, in some communities, people decide that certain things have to happen by variance when actually they can happen by special permit under section 6, with respect to nonconformities. Or sometimes it goes the other way, where a variance is treated as something that can be granted much more easily than it was contemplated by the statute. So, we just tried to make it really clear in the ordinance now exactly what's going to trigger a special permit with respect to a change in a non-conforming situation, and how those standards are different for different classes of nonconformity and different classes of use or structure, and really just spell it out. But I think that is, other than entertaining appeals, that's really, I think, the most significant role that the ZBA is going to have under the ordinance as recodified, is probably going to be with respect to nonconforming changes to existing nonconformities.
Thank you.
All right. Any final questions, comments from the board?
Oh, thank you.
All right. Well, thank you all. I really appreciate it.
Thank you so much.
Thanks, everybody. Just one quick last offer. I know this was a lot. I appreciate the level of engagement. If you have any other questions or want to delve into any part of the zoning any further in the future, don't hesitate to reach out. I can work with Jim and Mary and the rest of you to sort of facilitate future engagement too. So I don't want you to hold back on that.
Sounds good. Thanks, Aaron. Well, we're still in an official meeting, so I will present the motion to adjourn. All of those in favor, please say aye.
Aye.
All right, we're officially adjourned. Thank you, everybody, and have a good night.
Just because I'm here and I feel like I should say something. Technically, any vote taken in a remote meeting has to be by roll call. Even
Let's
a vote
do it
to
by
adjourn.
roll call.
I'm sorry to be that guy, but
Let's do it.
I heard it, so
All right. Mary, can we have a roll call?
Yes. Member Catalese.
Wait, I need a second if it's going to
Oh.
be a roll call. Who seconds?
Okay.
I'll second it.
All right.
Was that Maggio?
Yes.
Okay.
Yes.
All right. Member Catalese.
Aye.
Member Gilrain.
Absent.
Member Massey.
Aye.
Member Olson.
Yes. To adjourn.
Member Christopher.
Yes.
Member Maggio.
Yes, to adjourn.
Thank you. Member Crowitz.
Yes, to adjourn.
And Member Lopez Hernandez.
Yes, to adjourn. The yes and ayes have it.
Amen.
Good night, everyone.
Good
All
night.
right. Have a good night, everybody.
Thank you. Bye.
Right.